Brown.
Oh, that was, you were up for an arraignment this morning.
Yeah,
That was at 8:30.
Yeah, I dropped my son off at 8:30. I didn't know because the court didn't open.
Okay, so what we have to do,
So I'm trying to figure out how to get it.
Well, I don't think you're going to.
County.
You're not going to. I don't think you're. Are you going to have time to address that? You want to go through an arraignment?
Please.
That's fine.
Thank you.
Then you go discuss it with Mr. Sierra.
We talked already.
What's that?
We talked already.
You already talked? All right, well, let me finish.
Form's already submitted.
Okay, let me take care of these here quick and I'll just get right to you. I need that file. Let me go get that file for you.
For Brown, yes.
Brown. You need to be here on time or else you're going to get yourself a bench warrant. You got to be careful about that.
Yeah, I got the notice. I just didn't know the time. I got the email right here. You don't have a time on there, so I was trying to get in touch with you guys. That's why I'm here right now.
I already looked at the notice.
And I called you guys
very specifically stated the time, sir. So I'm just letting you know that.
No, I can show you my email right now. I got it from this guy right here. You got his name on it. Is it Dario?
That's Mr. Sierra, but that's the email isn't the notice.
This is the notice that I had.
Let's go in the record in the matter of People State of Michigan versus Brown, file 2444177FY. And state your name, sir.
Quentin Brown.
Assistant Public Defender Dario Sierra appearing on behalf of Mr. Brown for the purpose of arraignment.
Very good.
We have reviewed that felony file. I waive reading at this time. I'm speaking with him. He has asked that it's set for the probable cause conference in the prelim. After he has just advised now that he would like to self-represent. So court-appointed attorney is being denied by Mr. Brown.
Well, it's not being denied. He's
It was
just
previously
declining to
granted,
accept it.
so I-
All right. All right. You sure about that? You want to represent yourself when someone goes to school for many years to learn how?
I know what's going on better than anyone that can, because it's not right. Like, I'm not.
It is your right. It's your absolute right to represent yourself. The point of I just want to.
I got proof. I got proof.
Hold on. Okay.
I just want to talk to the prosecutor in my case.
Okay, and that's fine. I'm just gonna right now, what I say now for the next moment is going to be something I want you to listen to only for the sake of protecting you. The only reason I'm making the statement is to protect you from yourself, which I have to do a lot with people, okay? So this is not just a matter about you, it's about anyone that wants to represent themselves. I go through this with, okay? And what I want to be sure is to not have you make statements right now about the case because we're on the record and I don't want anything you say now to be able to be used against you as you go forward, okay? That's just to protect you. That's the only reason I'm saying that, all right? What I want to also go into is the fact that I'm going to give you the spoiler alert. You absolutely have a right to represent yourself, so I'm not going to, you're going to have that right. But I want you to be very wide-eyed and thoughtful about whether or not you want to have someone who is, who does this for a living, who is here, they know all of the laws, they know all of the various potential defenses and discussion points that they could have with the prosecutors to probably assist you in using your knowledge. So if you say you know all there is to know about your specific case, and that's probably true, no one would know that better. But if you combine that with the know-how of a prosecutor, of an attorney,
they won't represent me like I'm innocent and protect me like I own my life and my freedom.
My understanding of the quality and caliber.
They offer me deals and the prosecutor and I'll never get the chance to speak to them.
They have an absolute requirement when the prosecutor makes what is known as a plea deal or a plea negotiation. They have a responsibility. They have ethical responsibility to share that with you. That's your decision, but they have to present it to you, at least for you to make that decision. But when I appoint an attorney to represent you, you're that attorney's boss. And if you decline a plea negotiation, then it's declined. That's up to you, not to them. So, I mean, like I said, I'm gonna go ahead and indicate here that you wish to represent yourself. That's fine if that's what you want, but I would be thoughtful about that. Because again, this is what they do for a living. You know what I'm saying?
Well, I know in court that they had to find me beyond reasonable doubt, guilty beyond reasonable doubt.
That is
So
true.
I felt comfortable representing myself because I know for a fact I'm innocent and I haven't committed any crimes.
Okay, well, okay,
But
and that's
anybody-
fine. We can
Anybody that
absolutely,
you can represent, they don't know. They don't know.
well,
100%.
but,
They can go home and sleep and be like, they don't know me.
okay,
They don't know
all right.
if I did these things or
Here's
not.
the thing. What happens though at a trial, if you're representing yourself, and again, the end result of this is you're gonna be able to represent yourself if you want, but it's going to be not you, it's not gonna be a judge, and it's not gonna be the prosecutor that makes a decision as to whether or not you are indeed guilty. It's gonna be a jury,
I know.
and they're gonna have to, and they're
It can
gonna,
be you
it's not gonna be me.
or whatever it is. I guarantee you, you will be changing this verdict after I got what I got to say.
Okay, the question is, and I don't know what your evidence is, but the thing is, if you have an attorney to assist you, that helps you get that evidence in. Because there are some things that cannot be brought into court. And they know those rules. I don't know if you do or not, maybe you do, but if you do, that's fine. But there are some things that cannot be brought in, things that are considered hearsay, things that don't have a proper foundation, things that may not be authenticated.
Well, cash, like you paying me on the table. and
Mr.
like,
Brown, you're on the record right now.
I don't want you making any statement, sir, that is going to incriminate yourself. I
It's not
don't.
gonna incriminate me, sir.
Anything you say
All
though,
right.
sir, can be used against you. because
Exactly.
This is a court record.
Yeah, exactly. I just don't want
I'm gonna
anything.
do that in court. I'm in court now.
You are in court and they can use
This is
this
my
record.
defense. This is
All
what
right.
I'm gonna use.
That's fine. All right. I'm going to go ahead and indicate that you're declining court-appointed attorney. That's fine.
That's what I'm saying. Like he right here, you don't even want me to get my record across. This is what I'm here for.
Well-
I came in good for it because I want to press charges against him. I want to talk to the sheriff after this. And Mr.
All right.
State Police,
This is
and I have
this
my
is-
evidence.
This is my concern, is that you don't fully understand the process. And that is not to say that you are not intelligent or anything. This is not what you do for a living. That's why most people wouldn't understand the process. But if you're determined to represent yourself, and I've tried my best to convince you, maybe you want the assistance of someone to help you. But if you don't, I'm going to indicate you're denying the request for court-appointed attorney. Now we have to address bond.
I just don't feel like they would take care of my.
Okay, but that's not been my experience. My experience is that they are very effective, but okay. We have a $2,000 personal recognizance bond, and I am going to continue that. And then now the dates for the probable cause conference are as December 5th, and the preliminary examination, that's going to be December 10th. That's going to be at 9 a.m. That's the prelim. And the probable cause conference that on December 5th, that's at 1:00 p.m. Okay. Now that one you can attend by calling in and discussing the matter with the prosecutor.
Well, I
But
get notice.
I'm giving you notice right now.
No, like paper notice.
You're going to get, they'll send
I
notice.
could forget.
Well, you've got to write it down because I'm giving you have notice right now, sir. This is your notice. Yeah, so if you don't show up, you're not going to be able to come here and say that you didn't get the notice because a bench warrant will definitely.
Said 9 a.m. for what date?
9 a.m. on December 10, 1 p.m. on December 5th.
December 10. Could this be up here by Zoom?
The December 5th, you can appear by Zoom. December 10, you have to be here physically.
So if I wanted to, it says that's civil suit. I can't press charges against.
A civil suit would not be what we're doing here. So
I can't even press charges against the person that's doing this against me.
Not in this forum. I mean, if you decide you want to bring some sort of different matter, that'd be a different matter. That would be a completely different case. And it wouldn't be a criminal case. It sounds like that would be a civil case.
Is it criminal what he's been doing though?
Well, then you have to have the prosecutor make a charge on that.
That's what I'm gonna, that's my intention.
Okay, well, there you are. There you have your probable cause, December 5th, preliminary examination, December 10th. Need to be here in person for the preliminary examination. You can be here by Zoom for the 5th.
So the 9 a.m. is in person?
That's right.
Okay.
Good luck to you, sir.